This is exception 2. That culpable homicide is not murder, where the offender does the offending act in exercise of his right of private defense of person or property. The exercise of right of private defense should be done in good faith, which means with due care and attention. If, despite due care and attention, the offender exceeds the power given to him by law and causes death of the person against whom he is exercising the right of defense, then exception 2 may be applicable, provided the act was done without premeditation and without any intention of doing more harm than is necessary for defense. This is exception 3. That culpable homicide is not murder, where the offender is a public servant and he exceeds the powers given to him by law and causes death by doing an act which he believes to be lawful and necessary for due discharge of his duty as such public servant. And this belief must be in good faith, that is, with due care and attention. And lastly, there must not be any ill will towards the person whose death is caused. If all these ingredients are satisfied, then this culpable homicide shall not amount to murder. It will be punished as culpable homicide only. This is exception 4. That culpable homicide is not murder, where the act is committed without premeditation, in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner. There are several ingredients of this exception. Let us see them one by one. Before we go to the ingredients, let's see the explanation, which says that it is immaterial which party offers provocation or commits the first assault. Both parties are thereafter treated as equal. When we look into the essential ingredients, we find that sudden fight is an important feature of exception 4. What does sudden fight imply? It implies mutual provocation and blows on both sides. In whatever way the dispute might have started, the subsequent conduct of both parties puts them, in respect of the guilt, upon equal footing. Then there should be no previous deliberation or determination. The fight should break out suddenly. Both parties should be more or less to be blamed for the fight. The fight may be started by one of the parties, but if the other party had not aggravated it by his own conduct, it would not have taken the serious turn it did. There is then mutual provocation and aggravation, and it is difficult to apportion the share of blame which attaches to each fighter. It is further required that the heat of passion must continue and there must be no time for the passions to cool down. Also, for application of exception 4, it must be shown that the offender has not taken undue advantage or acted in any cruel or unusual manner. The expression undue advantage as used in this provision means unfair advantage. Let us now compare the provisions of exception 4 with the provisions of exception 1. There are some similarities and some differences. Exception 4 is founded upon the same principle as exception 1 because in both there is absence of premeditation. So this is one similarity. In both these exceptions, the act is caused without premeditation. And now the difference. While in case of exception 1, there is total deprivation of self-control, it is not so in a case of exception 4. There, it is only the heat of passion which clouds man's sober reason and urges them to deeds which they would not otherwise do. So the difference is that under exception 1, there must be total deprivation of self-control. Under exception 4, that is not the requirement. Heat of passion will be sufficient. Next, the similarity is that in both exceptions there must be provocation, but the injury done is not the direct consequence of that provocation in exception 4, whereas in exception 1, the injury is the direct consequence of the provocation. We now come to the last exception, that is exception 5. Culpable homicide is not murder when the person whose death is caused is above the age of 18 years and he had consented to the act which ultimately caused his death. So if he had suffered death or took the risk of death with his own consent, then this culpable homicide shall not amount to murder. This will remain as culpable homicide and will be punishable under section 304. Every culpable homicide is either a murder or a culpable homicide not amounting to murder. We can say that every murder is first and foremost a culpable homicide. Every act of culpable homicide satisfies the ingredients specified in section 299. If it further satisfies the conditions of section 300, then it is termed as murder. But if it falls within any of the exceptions, then the act is torn down from the offense of murder to the offense of culpable homicide.